Thanks for listening to this archive of Teaching American History's Documents in Detail webinar for Wednesday, the 23rd of September, 2020. The focus of tonight's program was James Madison's speech on the proposed amendments to the Constitution. As usual, Dr. John Moser, professor of history at Ashland University, moderated the conversation, and our two panelists were Dr. Jeremy Bailey of the University of Houston and Dr. David Alvis of Wofford College. Thanks for listening.
Good evening, ladies and gentlemen. My name is John Moser, professor of history and chair of the Master of Arts in American History and Government program at Ashland University. Welcome to another episode of Documents in Detail, Teaching American History's webinar series in which we bring together thoughtful scholars to have a conversation about historically significant documents. We encourage all of you joining us today to participate in that conversation by submitting questions via the chat box, and we will try to get to as many of those as possible. Within the next week, you'll receive an email with a link, and you may use that link to request a certificate of participation. There will also be a link in that email to an archived video and audio from today's program, which we hope you will share. The speeches, letters, and other writings that we're using for this year's webinars are all drawn from our book, 50 Core American Documents. They're also available at the Ashbrook Center's extensive, indeed voluminous, document database located at tah.org. The subject of tonight's program is James Madison's speech on the amendments to the Constitution, and to help discuss it are Dr. David Alvis, Associate Professor of Government at Wofford College, and Dr. Jeremy Bailey, Professor of Political Science at the University of Houston. David, Jeremy, good to have you with us.
Thanks, John.
Yeah, thanks for having me.
So, just to get us started, what is your why is this document significant? Why is it so much so that it is included in a volume entitled 50 Core Documents?
All right, I'll take a stab. So it's significant because it lays out fairly succinctly what the father of the Constitution understands by the Bill of Rights, and what the relationship is between the Bill of Rights and the Constitution. And so, as a way of pointing out some things here, I would say if I were a teacher teaching this, I would encourage my students to think about three things. One would be the substance of the amendments that Madison talks about, like what's going on there, what are the similarities and differences with the amendments in the Bill of Rights as we know them. Secondly, I would ask something about Madison's objective, and that is, does Madison believe that the amendments were necessary, and does Madison believe that the amendments actually improve the Constitution? And that'll come out, I think, more in our discussion. Do they improve the Constitution? And thirdly, I would ask my students to ask themselves if they think the amendments change the Constitution itself. In other words, did the Bill of Rights change the Constitution? Anyway, that's how I'd start that one off.
David.
I think I would also too. What I think is particularly interesting about the speech that Madison gives is that on the one hand, there's this enthusiastic tone, right, for the adoption of the Bill of Rights, almost a sense of urgency that we need to adopt this and that it's the right thing to do. On the other hand, it's the most qualified enthusiasm, I've ever read, right? Every sentence, right, has something like "it will sort of," or "it might be necessary." And so what's interesting, I think, about it is that on the one hand, you can I think see Madison's enthusiasm for a government that effectively protects rights, but there seems to be some hesitancy or some reservation about whether or not the Bill of Rights is the most effective way of doing that. And I think that really does, it helps, I think, students particularly think about the relationship between government, right, and the protection of individual rights. How do you go about effectively protecting it? And we tend to think, right, well, the major way that our rights are protected is through the explicit provision for those rights in the Bill of Rights. But Madison's reservations, right, about the utility of that Bill of Rights as a means of protecting rights really causes, I think, should inspire students to think about that for a second. Does the legal protection of rights in the Constitution, is that in fact the most effective way of going about protecting that? It's interesting too that the list of significantly long list of rights that Madison outlines in that document, they're all articulated in terms of negatives, right? Negative affirmations, right? Negative phrasing. Congress shall establish no law, right? That is, the phrasings are negative. And it would be interesting to ask the question, right, what if they were articulated as positives, right? Congress grants to people the freedom of speech. And I think that's a sort of helpful way of thinking for students to think about what is the proper relationship, proper understanding of the relationship of rights to our fundamental law.
As positive affirmations, of course, it changes the entire meaning, right? Suggests that the Constitution or the federal government is the source of rights.
Yeah, that's actually, it's interesting. One question I would begin with to talk with students about is why Madison wanted those to be placed in the body of Article 1, Section 9 of the Constitution. Why would that make sense? And if you look there, right, all of the provisions in Article 1, Section 9 are phrased as negatives, right? Congress shall not suspend habeas corpus except in times of war. So it's interesting to think about the location that he would have put those amendments, because it's obvious that he carefully thought about how that would, what meaning that would give to those particular provisions in the Constitution.
Kristen Salyer has a question right out of the gate. How does James Madison go from writing the Federalist Papers, which argued that a Bill of Rights wasn't necessary, to writing and supporting the Bill of Rights?
All right, so I actually spent some time once trying to sort this out in a kind of scholarly way, and so I'll try to give a condensed answer to that question here. There are competing views, and I'll talk about those competing views in just a second. But the premise is, in Federalist 84, Alexander Hamilton as Publius says that a Bill of Rights is not only unnecessary, but would also be dangerous. And it's an argument that James Wilson had made earlier in the convention, in the Pennsylvania ratifying debates. It's unclear whether or not Madison actually believed the aggressive version of that argument. What happens after the convention is that he and Jefferson begin an extended dialogue, or one of the things that happens is he and Jefferson begin an extended dialogue about the necessity of a Bill of Rights. And eventually Madison comes close to something like the Jeffersonian view and supports a Bill of Rights. The motivation for that conversion, however, is a bit complex. One explanation, a kind of cynical explanation, is that Madison did it in order to get elected. He was placed in a very difficult district by Patrick Henry to run against James Monroe for a seat in the House. And in order to win, he made a promise that he would support a Bill of Rights, and he had to disconfirm the rumor that Monroe's anti-federalist supporters were spreading that James Madison was against changing any letter of the Constitution, that he's for every tot and jittle of the Constitution. And so Madison let it be known to people, especially Baptists, that Madison would be seeking a religious liberty amendment. A second motivation is less cynical, and that is that Madison wanted to defang the opposition by taking away the kind of moderate case for it. And that is, for all of those people who were suspicious about the Constitution, but who did not want to change the structure of the Constitution, fixing the problem of the Bill of Rights was an easy way to bring over would-be moderates or would be people, now that the ratification was actually in place, to shore up support for the Constitution itself. So a kind of statesman-like thing to follow through on a promise and undercut the opposition at the same time. A final explanation would be that Madison actually got something, or was hoping to get something that he wanted. And one version you see here is buried in here is when he says, "No state shall violate the equal rights of conscience." And that is that Madison wanted to build in to what he thought the Bill of Rights might be an attempt to get the veto on state laws that he failed to get out of the convention. So I'll leave it at there, but there's a kind of variety of arguments judging from the kind of cynical political or electoral explanation to more kind of principled explanations.
David.
Yeah, the just on a couple of issues too that Jeremy's already mentioned. That is one thing that Madison, I mean, for most of the people who are proponents of the Bill of a Bill of Rights, they tend to see government right in the sort of in the way that British government works, and that is you have this concentration right of aristocratic powers that are in some ways independent of the majority that can easily abuse their power. And so in that context, right, a Bill of Rights actually makes sense. Some sort of charter, right, of your rights makes sense insofar as government is not a product of insofar as government is not founded on the people, and insofar as government is not conducted by majority rule. And so that for the proponents, right, of a Bill of Rights, right, that's kind of how they see government. Right? Madison sees it very differently. And that is, for Madison, right, the important question that you have to ask is, where is the power located? And his argument is the real power is located in majority rule. And that's what you have to be concerned with. And so in that context, a Bill of Rights is less effective if a majority, right, if you have majority rule, because majorities are more than happy to ignore these, what he calls parchment barriers, in pursuit of their own self-interest. So for Madison, right, the only solution to the problem of the self-interest of the majority or the self-interest of any faction is some sort of counteracting faction, right? So the famous argument of Federalist 10 is, how do you deal with the problem of faction, right? You create multiple factions, or you extend the orbit of the faction so that factions cancel each other out. So in that sense, right, a Bill of Rights is not particularly effective. However, he does in this speech seems to come to the conclusion that there might be some usefulness, right, to a Bill of Rights, not as a legal barrier to majorities, but as a tool of education, right, a means of educating public opinion and educating the majority so that it exercises self-restraint, or at least has some sense of shame when it violates individual rights. So I think he did, right, especially in his correspondence with Jefferson, which, by the way, I would really read along with this speech. I think he came to appreciate more the effect that a Bill of Rights could have on the education of public opinion. It wouldn't function as a restraint against majorities in a legal sense, but it could serve as a means of educating majority opinion.
Yeah, John, let me just register a slight difference I have with David, just to spice things up and keep it fun. So David's just given sort of the most principled account of the conversion, and that is Madison came to see Bill of Rights as having an educative component, that it would educate people. This was Jefferson's position. This was Jefferson's case for the Bill of Rights. I would say, without getting into the evidence, I'm not persuaded that you can demonstrate that Madison believed it. You can show that he twice said it. The question about it is an interesting question about the depth of his commitment to that position. I would invite people who are studying this document closely to ask themselves the question: does Madison believe that a Bill of Rights improves the Constitution? And it seems to me it's hard to answer that question completely in the affirmative for what David's already said, is that everything in the speech seems to be bracketed or modulated by some sort of qualification.
Travis Burnham has asked a question which I think you've addressed, but I'm going to exercise my right as moderator to tweak and sharpen that question. His question is: was it all an effort to placate the anti-federalists to accept the Constitution? My sharpened version of the question is: had it not been for this substantial body of what might be called moderate anti-federalist opinion, would Madison have moved forward with it?
So let me answer that question historically, and that is Madison's promise to support a Bill of Rights, which comes before this, I think is almost entirely motivated by Madison's desire to prevent a second convention. So the threat that Madison is facing is that the people who really want to trash the Constitution because of their fear about governmental power are using the absence of a Bill of Rights to prove the conspiracy theory that this is really a way to screw ordinary people in Western counties and whatnot. And the absence of a Bill of Rights and the unwillingness to have a second convention is the evidence of that. And so in order to keep the second convention being the moderate position that moderate people could run to, Madison realizes that a Bill of Rights needs to be promised in order to undercut people, especially in Virginia and New York, to help deploy. Now, it's a different question once you get ratification. Once you get ratification, it's a promise kept. And Madison's Federalist colleagues are kind of mystified why Madison actually cares about keeping this promise. And so if you read this speech, Madison's actually doing two things. He's talking to Federalists about the reasons why we might want to do this, even though we won and even though we have the votes. And he's talking to anti-Federalists who still have some of their lingering concerns about the absence of a Bill of Rights.
Yeah. David?
Yeah, I'm trying to remember, though. Let's see. By this point, right, by June 8th, let me just ask Jeremy a question real quick before I continue with this thought. By June 8th, right, has Virginia and New York, though, ratified, right, by that point? So it's only North Carolina and Rhode Island that are left. Is that correct?
This is June 8th, 1789. So this is the first Congress. So ratification's already happened because they're in the first Congress.
Yeah, though I think it's still at this point. I think Rhode Island. I'm not sure about North Carolina that they.
Oh, I'm sorry. Yeah, you're talking about the straggling states. Yeah, that's right.
But Virginia and New York are in by I think that by this point.
Yeah, there is no Congress without Virginia and New York.
Right. So yeah, so you've got you got Virginia, you got New York in. So you only have North Carolina and Rhode Island. So at this point, right, there's no strategy, right, in terms of trying to get ratification. But there was as Jeremy mentioned, there was a concern about a second convention, and in fact, Theodoric Bland, right, from Virginia, had actually put on the table, right, a proposal for a second constitutional convention, and was going to push, or at least, I'm sorry, had put on the table much more substantive amendments, right, along the lines that the Anti-Federalists wanted in the second convention, and put them on the table as a possibility through Article 5 approval for amendment. So, I mean, there is a strategy of Madison here, and that is to cut the legs out from under that movement.
Right.
I do think, though, that Madison is not necessarily. The interesting question is who Madison is trying to persuade. I certainly doubt that it's the Anti-Federalist leadership, because they're pretty entrenched. They're not gonna budge on this. But you do kind of have these middle of the roaders who are, a number of them are followers of these Anti-Federalist leaders. And if you can emphasize the Bill of Rights, but without these structural changes, then you can break those followers of the Anti-Federalist leadership away. And that, right, would be critical to stopping a second constitutional convention. So there is a real imperative for his argument. The other thing, too, is that Madison really had to push this through very hard, because he asked to submit this to the committee of the whole, and they attempted to refuse him by trying to push it over to a select committee. And then Madison just had to talk over them in order to get the proposal out. So he did have a sense of that this was an imperative moment. You had to block these proposals that were being begun by people like Theodore Land, and that this had to be done now. So there was a political expediency about it.
David will appreciate this. David and I were two authors on a book on the removal power. There's a huge debate on the removal power this very week, this very month in the first Congress. And so when you read these debates, they're actually spliced in with a debate on the removal power. And I once looked at the votes, and the votes in Madison's coalition on the Bill of Rights and Madison's votes in the coalition on the removal power are the same people, which is to say this was basically a Federalist versus anti-Federalist voting coalition as early as now.
And the other thing too is that so these arguments are going on at the same time. Most people are completely uninterested in the amendments argument. What they're focused on are how to design those executive offices, right, and who should have the removal power over those offices. So a lot of the debate, if you look at the records of the debate, a lot of the debate is people saying, why are we debating this at all? Why are we discussing these amendments? Who cares?
Yeah.
What we should be focused on are, the imperatives of beginning a new government with those executive offices.
That's right.
We mentioned that the two states that had not yet ratified at this point were North Carolina and Rhode Island. What was holding them back? Was it this issue? Or was there something else going on that was more specific to those states?
With Rhode Island, it was definitely dysfunctionalism. And then the particular aspects of North Carolina, I forget, Jeremy might remember what their calculation is here.
I don't tend to think it was this issue narrowly. I tend to think that this issue was just a part of a bundle of other issues. But there's a great, I don't know. I should say I don't know. There's a great book on the subject by Robert Goldwyn called From Parchment to Power: How James Madison Used the Bill of Rights to Save the Constitution, or something like that. But part of what Goldwyn talks about is that by proposing, and this is another answer to Travis's question, by becoming the person who was leading the charge for a Bill of Rights, Madison co-opted it. And so he's the person who took the 200 or so proposals from the Anti-Federalist, most of which were about governmental powers, the war power, the veto power, blah, 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 the taxation power, and took out all of those things and reduced the 200 proposals, mostly about power, to a few rather uncontroversial proposals about various rights.
And it turns out the states that were interested in a second constitutional convention, right, actually made this quite helpful in the way that they divided up, because they would create two lists, right, of concerns, right, that they wanted to see amended through a second constitutional convention. They created one list that was the specific Bill of Rights, and then they created a second list, which were all the structural changes. So that actually ended up helping Madison a lot in the debates, because he could just say, well, look, I took their entire list, and then just forget about the second list, right? Not mention that list. But because they had outlined it that way, I mean, it actually made Madison's argument much easier to push through just on the specific list of individual rights to be protected.
Shayla Nelson asks, Gordon Lloyd, I'm going to throw some Gordon Lloyd at you. Gordon Lloyd, in last week's Saturday webinar, mentioned that Madison proposed putting the Bill of Rights as a preface to the Constitution, but Roger Sherman led opposition and blocked it. Why would Sherman have been determined to put it separately at the end?
Oh, because it would mess up the beauty of the Constitution, right? Which is, I mean, if you get this most ironic thing, right? So you have these anti-federalists, right, who want structural changes to the Constitution. And then when Madison says, well, okay, here's a Bill of Rights, and here's where I want it to be inserted into the document, particularly on the preamble. So you wanted a preamble, right, that basically, for the most part, copied the wording of the second paragraph of the Declaration of Independence, right, to be added to the preamble. And Sherman, right, so you're destroying the beauty of this document, right? And while Sherman is not really an anti-federalist, right, other anti-federalists agreed, right, you can't destroy the sanctity and beauty of the Constitution by adding this preamble. I would just add too that I actually am glad that got defeated, because the locution of that preamble would not be nearly as elegant with the addition. It would have made clear, right, the significance of the Declaration of Independence to the Constitution, but it also too, I think, it would have destroyed the elegance of the preamble's opening statement.
Let me add one, that there's of course the pride of authorship part, and there's a kind of rivalry between Sherman and Madison on that stuff. More fundamentally, Madison had a concern, more so than anybody else, about the problem of creating a fundamental constitution by way of a special ratification. And the issue that a separate Bill of Rights raises is whether or not it's somehow different than or less authoritative than the original Constitution. And just going forward, for example, if you have an amendment that gets more ratification votes than another amendment, is that amendment somehow more authoritative or less authoritative than other amendments? By creating them all into one document, you would avoid that problem and just have one fundamental document. I think that was the theory. He did not anticipate the degree to which the Bill of Rights would become legitimate and on an equal footing with the original Constitution.
Joe Rooney asks, Madison states at the beginning of his speech that his purpose is not to change the structure of the Constitution. Does he succeed? And I guess this goes back to the question you posed earlier. Does the Bill of Rights change the Constitution?
I guess one question is does the Bill of Rights after the 14th Amendment change the Constitution? And it seems to me the answer to that question is unequivocally yes. Though I think there might be some people who fight me over that claim. I do think that the Constitution, read through the 14th Amendment, is a fundamentally different document, so the Bill of Rights is step one of that. It's a necessary step of that. The other way to answer that question would be thinking about the 10th Amendment. The 10th Amendment is a structural amendment, and the question is, does the 10th Amendment change anything, and does the omission of the word expressly before delegated change anything once that raises its head, as it does in the debates itself? And Madison works to keep expressly out of the 10th Amendment, and limited government conservatives in the future forget that. For instance, Mitt Romney and Rick Perry quoted the 10th Amendment to include the word expressly back in 2012. Anyway.
Well, one other thing too. I mean, in the form, I think that Madison's amendments, Madison's Bill of Rights was eventually adopted. Right there, I mean, there doesn't seem to be a substantial structural change to the Constitution. But had the original form of his Bill of Rights been adopted, there probably would have been one substantial one along the lines that Jeremy mentioned, and that was states would have been prohibited from interfering with certain fundamental individual rights, right? Freedom of speech and freedom of conscience, and and so that eventually gets dropped, right? Rather, it only applies to the federal government. And that, for Madison, that was actually a very significant or very important aspect, right? For one of the things that Madison really lost on in the Constitutional Convention debates, right? One thing that he really wanted was this national legislative veto, in which a national majority could strike down the laws that had been passed by a state majority. And for Madison, that really turns out to be sort of a sine qua non of his vision of how a national government would improve upon the defects of the Articles of Confederation. One of the major problems is the lack of a check on majorities within the states. And in fact, he had written a letter to Jefferson right after the Constitutional Convention, in which he claims that this was a devastating loss, right? The not having this national legislative veto. And in some ways, I think he's actually tried to sneak this in through his Bill of Rights as a way of checking state majorities from interfering with individual rights. That would have been substantial, and it didn't happen. And so, as Jeremy pointed out, that doesn't really happen until you get the 14th Amendment that incorporates the Bill of Rights against the states.
We've got a comment from John Talley. It's ironic, is it not, that Madison wrote in Fed 10 that many factions are needed in order to fight faction, but he saw the problem of faction being primarily with Congress and not in the chief magistrate. Isn't it not the case that the chief magistrate could essentially become a faction of one?
Yeah, it's called Alexander Hamilton. And that's the lesson that he learned in the 1790s.
Yeah, I mean, at first, though, he doesn't, I mean, early on, he didn't see the executive as a danger because it's a weak branch of government. The real power is in the legislature because that's where the majority rule. I think that actually was a real big oversight on Madison's part, is not to see the executive as a potentially serious force. But he sees for him, right, the problem is the legislature. That's where you really have to worry about that, try to control the problem of majority tyranny. And going back to a point, right, that Jeremy raised earlier, I mean, I really, it is true, right, in this speech that Madison says, right, look, the benefit of a Bill of Rights is that it could be an education for majorities to teach them to temper themselves. But Jeremy raised an objection to that earlier, that in some ways it just doesn't fit the way Madison thinks, right? I mean, Madison always thinks politically. And the question is, how do you structure power so that you force, right, a majority to check itself via, right, some other interest or some sort of other exertion of power? And so it's I mean, for Madison, right, the solution is always, right, some sort of institutional structure of power, not a Bill of Rights. So you can see, like a national legislative majority, that would be a political way of checking state majorities. How effective a Bill of Rights in the end would really be in terms of protecting those rights and tempering majorities, I think is in some ways a debatable question for Madison.
Had Madison gotten his way, and this Bill of Rights been included in Article 1 rather than at the end, what practical difference do you think it would have made?
It might have made future amendments less obvious. I don't know. I mean, we don't have that many amendments that aren't in the Bill of Rights. I mean, take away the Civil War amendments from the Bill of Rights, we got very few amendments. So I don't know. Would you get the 11th and 12th amendments? Probably. So I don't know. But I mean, I think the one part of the object is to lessen the push for addition to the original document. But I don't know. Maybe I'm wrong.
I mean, I think there would have been a benefit to putting it in Article 1, Section 9. And that is, I mean, no one thinks of, for instance, well, let's see, I guess that one would be, for example. But if you look at Article 1, Section 9, right, all of the rights that you're entitled to, like the right of habeas corpus, all of those rights, right, are articulated not as positive rights that are granted by government, but explicit limitations on the power of Congress. If you had to put them there, it would have been clear, right, that what rights are, and that is something that you naturally have, and therefore government, right, has no power over. When you put them at the end of the document, they begin to be interpreted as sort of additional things. rights, right? Now you have a right of freedom of speech. If we didn't have that First Amendment, we wouldn't have the right of freedom of speech. And I think Madison, right, was thinking, right, you don't want the rights to be interpreted that way. And that's why you want to put them in Article 1, Section 9. Government doesn't have power over that to begin with. Therefore, it should not be interfering with those sacred rights. So in some ways, it would have been, I think, actually beneficial to our understanding of rights and the relationship between natural rights and law.
But the National Constitution Center would look very different. Right now, it's like 10% Article 1, 2, and 3, and 90% is the Bill of Rights. And so you'd have to redesign the National Constitution Center for sure.
Jen Jolly asks, could one argue that Madison, in advocating the Bill of Rights, was ultimately genuinely concerned about liberty and saw this as a means of guarding against factions at the national level?
The answer to that question would be that structural innovation that David and I have been talking about, and that is that in this process, Madison wanted to protect liberty in the states. And so he was going this provision that would prevent restrictions of religious liberty or liberty of speech and press within the states would be a significant step towards liberty for Madison. Absolutely. I don't think that he thought that the prohibitions on Congress were going to be, this is my view, a step gain for liberty, because I don't think they're going to add up to much. I think when he says there's little harm here and maybe something to be gained, he's saying what he believes, that there's probably not a big deal going on here. Now, to be fair, he's absolutely wrong about that. And the proof for that is if you look at the debate over freedom of the press and the way that John Marshall and other Federalists bent over backwards to interpret the First Amendment in a way that did not protect freedom of the press because a different word was used with respect to freedom of religion. I think Madison understated the extent to which the First Amendment would shape behavior about things like freedom of press and religious liberty.
Madison has an interesting argument, though, that we haven't mentioned about why you don't want a Bill of Rights, right? Why you don't want rights listed as a matter of law, right? Especially fundamental law. And that is that he says at one point, he says, look, imagine, right, you have the freedom of speech listed in law. But during a time of war, you necessarily have to, at some point, suspend, right, in a certain degree, certain types of speech. He says, no, if you have that listed as a matter of law, if you say you have a right to freedom of speech, Congress shall not interfere with your right to freedom of speech, and then you temporize or compromise during a state of emergency or a time of war, his argument is that when it's a matter of law and you suspend it, right, once in any shade whatsoever, you begin to think, well, then the law really isn't that applicable. That law isn't that permanent. And so then you begin to say, well, isn't this an emergency? Isn't that an emergency? And then eventually, right, no one takes the law seriously. So one minor aberration from the law, right, leads to the death of the law. And so and this is particularly problematic when it comes to rights. And so for Madison, what's important is that the way to really protect rights is about dealing with power. And you've got to check that power, right, and keep it limited. That's the only effective way. And sure, there are certain times, right, when there's a major compulsion to abridge rights, right, for something like the sake of war. But as long as you have an institution that can check power, eventually, right, the equilibrium will be restored once you get out of that emergency. But when it's a matter of law, there's just no going back. Whereas if you treat it as a matter of politics, rights as a matter of politics and power, the proper institutional arrangement can bring you back to the right position during a time of peace.
Okay. Okay, a lot of great questions here. This one is from Candy Collins. Were any of the 200 ever in the press for the citizens in the states to see, or were they just kept within the confines of the delegates at the convention? And would that have made the push for Madison to lean toward a promise kept?
So on the first part, Edmund Randolph, Patrick Henry, others distribute Clinton in New York distribute. And this is a part of their push for a second convention, which begins in December of 1787 with a circular letter by Randolph, the governor of Virginia, of course, the governor who didn't sign the Constitution in the convention, who eventually does vote yes on ratification. I guess in July or August, September, whenever Virginia ratifies. So Randolph is for it before he's against it, before he's for it. Anyway, the short answer to your question is yes, these letters, Mason's big published letter, they have lists of proposed amendments. And so I don't know about the extent to which all of the recommendations coming out of the states were published in a formal way. My sense is that some of them were published and circulated. But of course, there are other questions lingering here. The Anti-Federalists didn't generally have access to the printing presses in the same way the Federalists did. They were kind of locked out of the printing presses. And so the publicity wasn't as the same that the Fed papers got, et cetera. I didn't catch the second part of the question.
Sorry, let me get back to that. And would that have made the push for Madison to lead toward a promise kept?
Madison's promise kept is again, I think a lot depends on what you see as the motive, on this continuum from merely political to partisan. I'm sorry, merely political to principled. And that's a difficult one. I think there are other parts of keeping the promise. Part of it is there's a question that alludes to it, the alliance with Jefferson that is clearly in place by this point. It appears that both Madison and Jefferson seem to be thinking about an alliance that had already existed between the two in Virginia, and that likely will exist within the Washington administration. And so I would not discount the specter of Jefferson and Madison's behavior here. I certainly think it explains a lot.
David.
Yeah, I'll see. I'm trying to think. I was trying to think if I knew of anything about the distribution of the information. I don't know how. I don't know how if they were able to circulate information regarding the desire for a second convention. I know that it was fairly commonly talked about and was probably shared by many who voiced this argument right at in the ratification convention. So remember, the ratification conventions were fairly heavily participated in, and so and the idea of a second convention had been brought up at that point. So I imagine it was probably somewhat circulating information. But I think also too for Madison, right, the imperative is that they are making a formal proposal for this second convention in the first Congress, and so that's also too another reason why you want to get this done, and you want to get this done now.
There's also a technical answer to that question that I neglected, and Gordon Lloyd is good about pointing this out. The Massachusetts breakthrough is critical, and what happens in Massachusetts is this is January of 1788, and in Massachusetts there's a movement away from necessary conditional amendments to recommended amendments. And what that does is it removes the Bill of Rights as a necessary precondition for ratification and allows a promise of something like the Bill of Rights become permissible as a substitute. And that then becomes an invitation for the following ratifications to assemble their list of recommended amendments.
In fact, Jefferson, right, for a little while was considering the possibility of pushing for ratification by 9 of the states that would be necessary, and then encouraging the last 4 to hold out until the Bill of Rights was formally adopted, which would have been a disaster because that would be Virginia, because you got Virginia and New York left. So it would have been disastrous. Thank goodness for the Massachusetts formula, because otherwise, that a strategy like that could have really hurt in terms of ratification.
Another window on this is I think it's July of 1788. New York is about to vote no. And Hamilton is gloomy, and he tells Madison that they're going to have to vote for conditional amendments. And Madison gives Hamilton a lecture saying that conditional amendments don't work, because then that means that Pennsylvania and Massachusetts and New York will now have ratified on different grounds, and you won't have a true constitution. And so in that summer of '88, Madison is lecturing his fellow Publius about the urgency of not having conditional amendments. It'd be better for New York to vote no than for New York to vote yes with the condition attached.
Tricia Topping asks, you've touched on this slightly. To what extent did Madison serve as Jefferson's eyes and ears regarding the Constitutional Convention while Jefferson was in France?
Yeah, Jefferson had a lot more access than anyone in Philadelphia. The regular correspondence between Madison and Jefferson was substantial, and Madison, contrary to the requirements of the rules of the convention, was sharing with him very detailed information about the nature of the debates and what the conclusions were.
There's a book by Mary Bilder which has gotten a lot of attention. It's got some problems. I know Gordon Lloyd has some very cogent criticisms of some of its findings. One of its finding that I agree with, and it actually confirms one of my own impressions about Madison, is she argues that Madison began his convention note with the intention of there being an audience of one, and that one audience of one was Thomas Jefferson. And the idea was the notes were going to be a list of good guys and bad guys from what was likely going to be a failed convention. And so when Jefferson returned from France, her theory goes, Jefferson would learn what went wrong and what problems to avoid when Jefferson emerged and joined the victorious coalition to found a constitution. I'm making it a little bit more hyperbolic than she has it, but that's the basic story. And I actually think the basic story is right in the sense that a large part of what's going on is can be seen as part of Madison thinking about the person of Jefferson and how he's going to figure in with respect to national politics in the 1790s.
I got to read this. That's an astounding argument, right? But I wouldn't put it past Madison.
Going back to a comment that Jeremy made earlier, Jeremy, why do you think that the 14th Amendment definitely changes the Constitution? And can you give examples?
Well, yeah, absolutely. It applies to protections of individual liberties against the state legislatures. And that's not the case under the original Constitution. So under the original Constitution, Massachusetts could deny freedom of the press, but Congress could not. The 14th Amendment changes that, or at least under its interpretation post-1925 in the 20th century, the 14th Amendment changes that. And that's a fundamental restructuring of the original arrangement under the Constitution. Now, again, Madison would have preferred something closer to the 14th Amendment in that sense, at least with respect to certain rights, not with respect to all of them. Not the respect that seems to say searches and seizures or the right to bear arms, but with respect to religion, press, speech, the states wouldn't be allowed to deny those. So yes, I think maybe it's maybe you could say it's a good change of the Constitution. I'm not saying it's either bad or good. What I'm saying it is a change.
I think that's right. it is a significant change in the relationship between the federal government and the states. And I mean, in fact, I think the 14th Amendment is very much in line with the original vision that Madison has in proposing a national legislative veto that could veto state laws. Now, Madison, by the way, very rarely ever sees the court as a solution to any problem. But right, it would operate in sort of the same way, and that is that you would have a review of state laws and can strike them down, right, for being inconsistent with the protection of individual rights. So I think that's a substantial change. The question is, right, what is it between Madison's proposal of the national legislative veto that kills that, right, and the 14th Amendment? And I think probably one of the biggest reservations about a national legislative veto probably came from slave states, right? Because I think they figured, look, if they're the first thing that you use a national legislative veto, if you have a larger population in the North, would be to interfere with the institution of slavery. And so it's not really until that you get the 13th Amendment and the abolition of involuntary servitude that you can get something like the 14th Amendment and enforce those Bill of Rights against the states. Slavery would have made that impossible.
Tricia Topping asks, could this speech be viewed as the turning point in Madison's relationship with Jefferson? Do we see here the origins of the alliance that would lead to the co-founding of the Democratic Republican Party?
I believe the alliance is already there. They work together to secure religious liberty in Virginia. They work together to get other reforms in Virginia that fail. And so the alliance is already there. It is an important moment because their correspondence enters a period where it's probably as rich as it will ever be. So that's to say that there's an alliance, probably the most important political alliance in American history, maybe indeed in Western history, is between Jefferson and Madison. And there is basically no break in that alliance from the 1770s or 1780s until Jefferson's death in 1826. From 1787 to 1789, 1790, you get the most depth in terms of the letters. I suspect that their conversations turn to verbal conversations for the next 2 decades.
Intellectually, I wanted to ask Jeremy, intellectually, what is it, where is the bond between Jefferson and Madison intellectually? Because they do seem to disagree on everything, right? Is a Bill of Rights useful? I mean, Jefferson practically sees it as an absolute sine qua non necessity of the Constitution. Madison says, I don't think it's that useful or that effectual. When you've written on the differences between Madison and Jefferson, right, over whether on the origin of political power, right, or whether it should derive directly from the people or not. I mean, is there an intellectual bond, or is it just purely political?
No, I would say that their intellectual bond, what makes them so similar, is that they have a fixation on limited government achieved by consent of consenting individuals, and you don't find that in James Wilson or John Adams or Alexander Hamilton. They don't really care about that, as far as I can tell. Hamilton's concerned about good government. James Wilson's concerned about nature of the capital N. I can't really understand what he wants besides that. Adams is interested in solving the problem but there's not that emphasis on limited government through consent, and therefore a reading of constitutions in a consistent way that is always going to try to emphasize the question: did I consent to this power? And Jefferson and Madison are more or less on the same page there every single time, as far as I can tell. And so I call them kind of Southern Lockeans. And that there's a certain variety. George Mason might be another person in that kind of intellectual atmosphere.
Unfortunately, we have more questions than we're going to have time to answer. But here's one. Arnab Sirkar asks, in the document, the prevention of quartering is referenced as a potential amendment, and it, of course, eventually became the Third Amendment. Was the thought that propelled this amendment a direct result of the backlash from the Quartering Act passed by the British during their colonial rule, or were there other reasons? This does not seem like an intuitive natural law, yet it's so important that it appears as the Third Amendment so early on in the Bill of Rights.
Yeah, I mean, so the Quartering Act, right, of the British, right, was considered one of the most offensive, right, to to the colonists, and precisely because, I mean, just the immense amount of intrusion on your private life, right, being forced, right, to house a soldier, and also too, right, people knew that they were housing these soldiers who held a particular animus against them. So it was an incredible invasion, right, of your right to property and to your privacy. And so, I mean, it was truly, I mean, for them, it really stood out as a major violation of one's natural rights. But yeah, I think it was very much based on a response to the Quartering Act.
I can't add anything.
Yeah. Yeah, this is like the one amendment in the Bill of Rights that is not at all controversial. It's never been interfered with that I know of. No one has tried to refine it by saying, "Well, of course, there's militias and nothing like that." There,
I try to use it. I try to litigate under it, right? Whenever the children come home from school telling me that I have to do certain things, right? Then I say, well, that's like housing soldiers, right? In my house, right? You can't, but that's never worked, right? Don't try that in a court of law.
We might have to house contact tracers.
Anna Yoakum asks, how did Madison's Federalist views shape the way he viewed politics and the Constitution?
John, say that one more time. I'm sorry.
How did Madison's Federalist views shape the way he viewed politics and the Constitution?
I'm going to answer it this way. By Federalist, someone who believes in federalism, Madison is, for most of his life, a defender, or comes down on the side of people who are more concerned about protecting the authorities of the states or the rights of the states, with the exception of in the beginning when he's not entirely happy about the experiencing the Articles of Confederation. That means that starting basically 1 year after this speech, Madison becomes very interested in the rights of the states. We don't see it by the time of this speech.
I have a little bit of a difference on this. I actually think the Madison, right, who proposed the national legislative veto, right, is also the Madison, right, that sees states having the primary responsibility of protecting individual rights. So the question is, well, why would you have a national legislative veto if you thought that states, right, were the primary source of protection for individual rights? And I think the problem, right, is that states, right, can because right, states, right, can have majorities, right, that are abusive to rights. You've got to have some sort of umpire to protect individuals, right, against these majorities. But the function of the federal government was not, right, to take over the responsibility of protecting individual rights, but rather to operate as a sort of referee to check the states from abusing their power. And so it would be the states, right, that would have the primary duty of rights protections. The federal government would simply serve as a sort of adjudicator in cases where states failed to do that. It would just serve as a check. And so a strong national government in Madison's mind serves a very different function than a strong national government in Hamilton's mind. For Hamilton's mind, right, you want a sort of great centralized government that can be modeled on something like England, right, has these kind of imperial ambitions. Whereas for Madison, right, you want a strong central government that just sort of adjudicates between the states, right, but does not become, in some ways, the primary source of political authority or public policy making.
We are about at the end of our time. I'm afraid I'm not going to be able to pass along any more of the questions from the participants, but I'd like to before we conclude, give each of you an opportunity to make any final statement you'd like to on this document.
This is a great speech. It's a great speech as an example of someone who changed his mind, or at least his public position. So it's a great document to invite students to encounter for that. What are the explanations that Madison gives for this position? And it's also an invitation for his audience members to change their mind on the position. And so I think that's it's unusual and extra fun in that sense.
That's one thing I would say that it's a very helpful lesson for students is we tend to think about rights, right, and the protection of rights purely in terms of the legal system, right? So the judiciary, that's what a judiciary's job is, protecting rights. But that's not the understanding of the framers, right? That is the function of government as a whole is the protection of individual rights. And I think Madison, in the whole political context that he's working within, is a reminder that you really have to think, when it comes to the protection of rights, you have to think in terms of more than just simply laws. Protecting rights is a matter of designing good institutions of government that not only can be effective in protecting rights, but also too effective in controlling the powers of government. And so understanding rights in that way, I think, will give students a much broader understanding of the role of American government as a whole, not just the American legal system.
Okay. Well, I want to give a big thank you to both of our panelists, Jeremy and David, as well as to the participants who really offered some terrific questions. As a reminder, you will be receiving an email within the next week, and that email will include a link for a certificate of participation if you would like one. It will also contain a link to the archived webinar, which we hope you will share with your colleagues and also share that on social media. Help get the word out. If you've enjoyed this evening's webinar, please consider taking an online graduate course and our Master of Arts in American History and Government program. Both David and Jeremy, of course, are regulars in that program, so you can hear a lot more of their fantastic insights. You can find more information about our course offerings, as well as all sorts of other resources for teachers at teachingamericanhistory.org or simply tah.org. Our next Documents in Detail webinar will take place on Wednesday, October 21st, when our topic will be James Madison's essay on property. So more James Madison for you. Joining me to discuss it at that time will be Elizabeth Amato of Gardner-Webb University and Chris Burkett of Ashland University. We look forward to seeing you back here on October 21st. Have a great evening.
Thanks again for listening. You can find out more information about our programs and resources at teachingamericanhistory.org or tah.org.